I rise to have the bill shortly entitled the Proceeds of Crime Amendment Bill 2021 read a second time. Mr. Speaker, as has been earlier indicated in this Honourable House, the assessors from the Caribbean Financial Action Task Force are currently here on the ground to test the anti-money laundering and counter-terrorist financing capabilities of our Federation. This assessment, Mr. Speaker, is comprised of essentially two components. One aspect is focused on the legislative assessment that weighs the adequacy and completeness of the laws in the Federation as it pertains to anti-money laundering, counter-terrorist financing, and the latest area that speaks to counter-proliferation of weapons of mass destruction. The other component, Mr. Speaker, is an examination of the effectiveness, where the efforts of the state are measured in respect of applying the laws, in collaborating with relevant agencies, and generally combating criminal activity. The overall objective, Mr. Speaker, is to determine whether the outcomes of national cooperation, crime detection, investigation, prosecution are being achieved. Are criminals being stripped of the benefits of crimes? And even in the absence of a successful conviction, can tainted property or assets be removed from the proceeds of crime equation? It is therefore critical, Mr. Speaker, at this juncture, that we are sufficiently able to demonstrate that we have appropriate means to fully pursue the fruit of ill-gotten gains. The intention of St. Kitts and Nevis in this area, Mr. Speaker, is to sharpen and expand and equip our law enforcement authorities to be thorough and effective in the ability to properly investigate suspected proceeds of crime. Mr. Speaker, you will recall that we would previously have gone to the National Assembly with the Proceeds of Crime and Asset Recovery Bill. This bill was passed into law in 2020, but is not yet in force. There are elements of that legislation, Mr. Speaker, that still require some administrative interventions in order for them to be comprehensively aligned with the proposed scheme. And in that regard, Mr. Speaker, the proposal before the Honourable House today is therefore to adjust the existing Proceeds of Crime law to provide for a more expansive asset recovery scheme that would be ready for immediate rollout. It would do so, Mr. Speaker, by adjusting the confiscation and the asset recovery of the existing legislation. It is intended, Mr. Speaker, that the proposed amendment would be a short-term measure until we are fully able to build the comprehensive administrative and legislative frameworks to properly support the effective implementation of the Proceeds of Crime and Asset Recovery Bill. Mr. Speaker, the bill is therefore nothing new, but a short-term measure to do a phased introduction of the proposed asset recovery measures. Mr. Speaker, I just want to go over what we are doing here. Last year, we would have passed a new Proceeds of Crime and Asset Recovery Bill that should have replaced the existing Proceeds of Crime Bill, Act, that has been with us for some time. The old Proceeds of Crime Act has certain challenges to it. And while the police and the prosecution, the DPP's office, have had a number of cases where we have been able to exercise the Proceeds of Crime Act and recover assets in criminal convictions that go before the court, there is a question of it that it is very lax. There are loopholes, there are paucity of being able to deal with the question of civil recovery. Somebody has a lot of gain, no income, no way you're getting that money from to build and buy things. And therefore, how does one go after it if you're the police? You may not be able to get the criminal conviction where the person is doing nefarious things at the time, but you know they have the benefits of ill-gotten gain. And so the question is that civil recovery in criminal matters is one which is now being contemplated. This is the nub of the new Proceeds of Crime and Asset Recovery Bill Act that is not yet in force. What this bill will do, is to take the portion of that new bill, that new act that's not yet in force, and bring it into the old act temporarily until we get our act together with the new legislation that is not yet in force. It is what we have debated in this House.
Can you repeat that?
Huh?
That sounds very confusing.
It's very confusing. So let me go over it again.
Yeah, right, go ahead.
There's an old bill
Yes.
that has Proceeds of Crime Act. The police have been using it and have been able to use it a certain amount of effectiveness in relation to criminal matters. Last year, we passed in this Honorable House a new Proceeds of Crime Act that updated the old act, and the new act was to replace that old act. It brings a whole complete new section in it about civil recovery assets. And all we are doing today is borrowing that aspect of the civil recovery to put in the old poker bill, the old Proceeds of Crime bill. Is that more? I've tried to...
So the one that we passed last year will never come into...
It will come into force because that requires a certain amount of other administrative and legislative to bolster it. And we are not quite there yet in terms of the police advice and the advice from the prosecutors at this point in time. They need to have more work done at it. That's fundamentally what it is. That it will come into a thing. This is a temporary provision to be able to make us more compliant, technically compliant.
So this is dealing specifically with the assets?
That's the assets. Okay? There are other aspects of the Proceeds of Crime bill, for instance, that act that we passed that are very much needed, but do not really deal with what we require to show compliance, technical compliance with anti-money laundering. That's fundamentally what it is. The ambit of what we are doing has to do with ensuring that there are no gaps in terms of money laundering. And we can see that some people can money launder and they're not easy to identify. This is one that means to strengthen those loopholes and make it more amenable to make us technically compliant. A very simple bill in the sense that we have gone through this already and we are borrowing what was there last year and putting it temporarily into the old bill that has been around for some time. It's as basic as that. And Mr. Speaker, therefore, we just seek to adjust the existing Proceeds of Crime legislation in three main aspects. Clause 3 of the bill seeks to expand the definitions that are captured in the legislation. Importantly, the expression of cash is expanded to include electronic cash, as well as any monetary instrument that is prescribed as cash. Mr. Speaker, we would earlier have spoken to the use of virtual assets, and we will look at it further when we come to the next bill, which is a recognition of digital currencies, in essence, an electronic form of cash. The expression criminal recovery investigation is also distinguished from a traditional criminal investigation. The focus of a criminal recovery investigation is to conduct the full line of inquiry to determine whether a person has benefited from their criminal conduct, to ascertain the extent to which someone has benefited from that conduct, and the whereabouts of the property or assets in question. Mr. Speaker, the bill also speaks to the adjustment of Part 3 of the existing Proceeds of Crime legislation that provides for facilitating investigations and preserving property liable to forfeiture and confiscation orders. The bill seeks to provide a level of depth and detail in order to better assist law enforcement on a whole in the use of investigative tools. It thus seeks, Mr. Speaker, to bring greater certainty and transparency to the investigative process. This proposed expansion of the legislation should also assist the courts in better being able to interpret the legislation and the powers being exercised under it. In that regard, orders that may be utilized by investigators are sought to be expanded in accordance with Clause 4 of the bill. This part of the bill covers disclosure orders, customer information orders, and seeks to expand existing monitoring orders. Mr. Speaker, Clause 5 of the bill seeks to expand Part 4 of the bill to facilitate the application of civil recovery that I referred to earlier in regard to property obtained through unlawful conduct, property that has been used in or in connection with or is intended to be used in or in connection with unlawful conduct, and to ensure that the powers conferred by this part, which are exercisable in relation to any property, including cash, are exercisable whether or not any proceedings have been brought for an offense in connection with the property. Mr. Speaker, the bill essentially proposes for the detailed procedures to facilitate the application and enforcement of these procedures, which are premised on retrieving the benefits or proceeds of unlawful conduct. Mr. Speaker, this kind of framework provides a sound foundation to a system that is focused on good governance, transparency, and a firm application of the rule of law. This system has now been successfully applied throughout the OECS. We have had it in St. Vincent for some time, where the authorities there have been able to recover significant amounts of property that were considered to be tainted. In Dominica, in Grenada, and Antigua and Barbuda. Mr. Speaker, I will not endeavor to go through with any greater detail the provision of the bill, since, as I indicated earlier, the bona fides and rationale for the policy would have been already fully ventilated on an earlier occasion last year. Mr. Speaker, I thank you and this Honourable House for its intention and wish the bill safe passage through this Honourable House. May it please you, Mr. Speaker.